Good night, everyone. This is U.S. Immigration Attorney Sharifa Tharpe, and I am here live to answer your U.S. immigration related questions. So go ahead and start to put your questions in the comments, and I will go ahead and answer your questions. Now, I want to formally introduce myself. For those of you who don't know me, I'm U.S. Immigration Attorney Sharifa Tharpe, and I help clients to get their green card and status in the United States. So I come here every night at 9 p.m. to talk about a particular topic that I think is important for you to know, and also to answer your immigration questions. Actually, your questions are my priority. And what I find is that when one person has a question, it really represents many other individuals who have the same question. And so when you ask that question, it really helps me to guide the conversation and give you the information that you really want to hear. So go ahead and put your questions in the comments now so I may answer. Also, one thing I want to tell you is that I'm here at until 9:30 because I have a pre-scheduled live at 9:30 every night on Instagram. Now, you can join me over there if you want to continue the conversation, or if somehow I have to leave and I don't get to answer your question. You can hop on over there by just going to the link in my bio and clicking on the Instagram button, where it'll take you to my Instagram page, and you can just hop right back onto the live with me and keep the conversation going. So while your questions come in, because that's what I really want to hear tonight, get right now are your questions. But while your questions come in, I'm going to be talking about adjustment of status in the United States. Yesterday, we talked about consular processing. That's a process of having sponsoring an employee or a relative who is already outside of the United States in order for them to come over into the United States from outside. Now, adjustment of status is the process of applying for permanent residence while staying in the United States. Now, while anybody who qualifies through a relative or through an employer cannot always apply from outside of the United States. Thanks, Ian, for sharing the live. I appreciate that. Only certain individuals qualify to adjust status in the United States, and I find that many individuals make a lot of mistakes thinking that they qualify for adjustment of status just because they qualify to apply for permanent residence. So I want to clarify who qualifies for adjustment of status. So can a person being in the U.S. do asylum after 4 years? It really depends. It is possible, but it depends. Did you experience a change in circumstances? As in, did the circumstances in your country change so much that 4 years ago or over the past 4 years, it was not an issue, but now it has become an issue and now you have to apply? Another thing is, if you've missed that 1 year deadline, did you have exceptional circumstances that prevented you from applying at the time? Did you have an emergency? Did you have to deal with another issue that really prevented you from applying? So that's going to definitely require a consultation to determine whether you can move forward with an asylum claim after 4 years of being here. But it is possible. Also, if you've been here with legal status, so if you've been here with legal status, but now you've fallen out of status and now you are in danger of being deported, then that is also a way to present changed circumstances. So that's my fear. I will have to go home. So Kerry, real estates. Yep, definitely. I am going to talk about adjustment of status, and some individuals do find out that they have to finish the process in their home country, but there may be solutions to fix that, even if they have to leave. So, who qualifies for adjustment of status in the United States? It's going to be anyone who can maintain their legal status in the United States for the entire duration of the adjustment of status process. So the adjustment of status process is taking 2 years or 18 months. at the time that you come to, for example, the interview, or you come to the point of the end of the adjustment of status, you must also prove that you have legal status. But keep in mind, there are exceptions that I'm going to talk about. So I got brought to the US when I was 6 illegally. I tried marriage, but it got toxic. So Leo Lopez, that's where I want to, consultation is very important here, because you came when you were 6. So there may be options related to that. How did you come here? Who took you here? How were you treated when you got here? What did you have to do? And in your marriage, what happened in the marriage? Now, I noticed you said it was toxic. If this is a US citizen or a legal permanent resident, and you were in that marriage and it became toxic, as in they mistreated you, you were verbally abused, emotionally abused, manipulated, there was name calling, there were threats about your immigration status, there may be a way to apply on your own based on what happened to your marriage. Now, if you are divorced or separated, you can still apply for this. If you're separated and not divorced, you could still apply for this based on the mistreatment or abuse or extreme cruelty. If you're divorced, you still have to apply for this. You have to make sure you apply for this less than 2 years after the divorce. If 2 years passes, then you will not qualify for this. So my fiance got through with his kids how long to get the spouse up there. So my fiance got through with his kids how long to get the spouse up there. So I'm not sure what. Now, usually if the spouse is a US citizen, then it is going to take it's taking right now about 18 to 24 months. That also goes for the spouse of a permanent resident. So it's taking about 18 to 24 months, but it really depends on what the particular circumstances are. But I'm giving you a timeline based on marriage to a US citizen and right now a legal permanent resident. The reason why marriage to a legal permanent resident is taking as long as if you're married to a US citizen is because there's no immigrant visa number wait list. And because of that, you're able to get through the process after your petition is approved. And so it's a shorter process. And yes, believe it or not, right now, 2 years is actually faster than other processes. So when can I have the conversation with my employers that I'll need sponsorship to stay in the country? So unfortunately, that would definitely have to be up to you. It really depends on what your situation is with your employer, how well you're doing at work. But this is something that you would have to navigate on your own. Leo Lopez, I'm heading for divorce. So I encourage you, schedule a consultation. This could be a path for you to obtain your own permanent residence. Now, when you're applying for this based on mistreatment, even if you came into the country without permission, even if you overstayed your visa, you could apply for this as long as you meet the requirements based on mistreatment. And also, if in a case like this, you would be able to get a work permit while the process is pending. And you eventually will get to the adjustment of status where you would get your 10-year permanent residence. So it could possibly be a path for you, especially since you've been here and I can just imagine the struggle. And so I encourage you to schedule a consultation. There is a scheduling coordinator who is available up until 11 p.m. tonight to take your call and schedule. Also on your off days, tomorrow and Sunday, if you're off between noon and 5 p.m. So currently here, Cheyenne, let's see. So you're currently here on OPT. So yeah, so if you're here on OPT, then I can imagine your maximum time you have is a year. And so you definitely want to get to that point of having that conversation to see where you can go. Is your employer willing to apply for you? My parents brought me, yes, she's a citizen. So Leo Lopez also, If you are the child of a U.S. citizen who is under 21, I don't know if you're over 21 by now, but if you're under 21, however, you're married. So if you're married, you wouldn't qualify as the immediate relative of a U.S. citizen. And you would be the married, right now you're going through a divorce. So when you get divorced, you will become the unmarried child of a U.S. citizen. How fast your process goes and whether you qualify for adjustment of status, that means to apply for permanent residence here in the U.S., is really going to depend on your age as long as you're divorced. So if you're under 21, you could still take priority in the process and apply for permanent residence while staying in the U.S. If you're over 21, then there is another process where you would have to apply for a waiver to get forgiveness for the overstay. I know even though it was not within your control to come here when you're 6 years old, unfortunately, you would still have to apply for this waiver. And this would allow you to leave the country temporarily to attend the interview at the embassy in your home country. It is a safe process once you have an approved waiver. Can an 18-year-old American live on their own? This is a very general question, and so I don't know what the context of it is. This is not legal advice, definitely not related to immigration. Generally speaking, 18-year-olds are considered adults in the United States, but that's really going to depend on your circumstance, and it may not be. If it's a CRAW 938, if this is somehow related to an immigration issue, can you clarify so I can explain or answer your question better? Hi there, K9 Kelsey. It's nice to see you. How to get a green card while on asylum? So once you have you've been granted asylum, you can apply for adjustment of status after a year of having asylum. Thanks so much for sharing the live. I appreciate that. And XOS18, thanks for the follow. I appreciate it. So once I have approved waiver, I'll be able to return from Jamaica. So yes, once you have the approved waiver, you just go to the interview. You can attend the interview and then fly down for the interview. And then as soon as the interview is over and they give you back your immigrant visa, which would be about 2 to 3 weeks, just for them to process it and get it back to you by courier. Usually in Jamaica, it's DHL. They would send it back to you and you would fly back to the US and become a permanent resident. Hour long after getting your receipts from USCIS is the biometrics. So the biometrics right now, it's taking months, unfortunately, because of the backlog. Now, the best way to figure out, I wouldn't be able to tell you because the biometrics, the timeline right now is very erratic. Before COVID, it was very predictable. I could tell you four weeks or 4 to 6 weeks after you got the receipt notice. However, right now we're looking at 4 months, even as long as 6 months. And so the best way to gauge how long your entire process could be is to go to uscis.gov, go to case processing times on the homepage, just scroll down a bit, you'll find it. And then look at the service center that's processing your case. And then at that point, you would be able to see the time range for the particular form. Do you have to go with your spouse at your biometrics interview? No, it's not an interview. It's just a fingerprinting appointment, and usually, unless you're instructed to, so if you get the notice and it says you should, that's when you need to follow the instructions. However, usually you just go by yourself to do the biometrics. Honey, Zert, thanks for sharing. I appreciate that. If a child goes to the US and overstay for 8 months and her visa is not expired, what advice can you give? So now, even though the visa is not expired, the visa isn't expired, but keep in mind that the officers can still see it as a violation of the immigration terms, the terms of the visa. And so the child would not be barred, but going back to renew the visa or maybe even trying to get back into the country, the officer can definitely pinpoint that issue and refuse entry into the country because of that overstay, or revoke the visa and not renew it. So those are the dangers. Now, another thing though is that when you overstay in the United States, there is this misconception that you have this visa, you overstay, but it's valid for 10 years. And unfortunately, once you violate the terms of your visa, then it's not going to necessarily be valid anymore. So that doesn't allow you to then say, oh, I'm going to try to correct this by traveling back outside of the country after you've overstayed. But the good news here, and I definitely advise you, definitely, because the information here I'm giving you is not personal legal advice. It is general information. And so I advise you to get a consultation because there may be a solution to this situation. However, with the child, anybody who is under 18 and they're currently undocumented in the United States, they don't accrue unlawful presence. And what that means is that even if the child overstays, so if this child is 10 years old, for example, they overstay and they end up leaving the country, they will not have a bar for 3 years. They would not have a bar for 3 years if they overstay over 6 months, or they wouldn't have a bar from re-entering the United States for 10 years. That doesn't start to accrue. That doesn't start to go against the child until they turn 18 years and 6 months, right? So there's still time for them to correct their situation and fix their status. For example, if the child doesn't qualify to adjust status in the United States, but they can do consular processing, meaning they can wait up here, they can go to the interview, the officer will not penalize or deny the application based on the overstay, because it doesn't accrue against children. However, I don't know what your situation is, and to get accurate legal advice, you should definitely call and schedule a consultation. You can call 561-405-4889. The number is all over my videos. You can also go to the link in my bio. It's gonna take you to the website where you can fill out a contact form or call and schedule. You're welcome, Kerry Real Estate SD. Can a 2-year-old baby who is a green card holder stay out of the US for more than 6 months? So that would not be a good idea, because regardless, that baby is still a green card holder and they would be at risk for losing their permanent residence based on the decision of the parents, of course. So you want to make sure you get legal advice. Now, keep in mind that there are ways, if you have to leave the country, there are ways to do it in such a way that you don't put your green card at risk. So before you get up and leave the country, is there a justifiable reason that you need to be outside of the country? If so, there's something called a re-entry permit that you can apply for that will give you permission to stay outside of the United States and do what you have to do and then come back. And as long as you come back before the date that they provide, it will not be held against you. So you are welcome, Cerberus. Ricky, it's nice to see you and thanks for tuning in. Keep putting your questions in the comments, because as already I have addressed issues that I wanted to address, which was adjustment of status. Now, with adjustment of status, not everyone who is in the United States will qualify for adjustment of status. However, first of all, you have to maintain legal status. But suppose you can't. Suppose you haven't. Suppose you've already overstayed. Is there still a way to adjust status in the United States? And the answer is yes, in select circumstances. I'm going to talk about those. So the first is if you are the immediate relative of a U.S. citizen. So you came into the country, overstayed your visa, or you came in with some sort of permission and overstayed, right? You can still adjust status in the United States as long as there are no other disqualifying factors such as criminal record or any other immigration violations. In this case, once you go ahead and adjust, you can adjust status. Once you go ahead and apply, You can apply for a work permit while you're here, which is coming about 6 to 8 months now. And a travel document. If you do need to travel, at least you have that document to be able to leave the country and come back. Right now, the process is taking 18 to 24 months. Now, if you don't fall within the category of an immediate relative, such as if you came into the country without permission, so without a visa, or you are not the immediate relative of a U.S. citizen, there are or maybe other options. And I'm going to talk about those. For my sister-in-law to attend her mother's funeral in Texas, it's just for them to apply for the visa. Right, so if she's currently in Jamaica and she needs to attend the funeral, they would definitely have to apply for a visa, and they could, right now, there are ways to request for an emergency type situation, and this may very well be it. What of a child who is a U.S. citizen but has stayed out of the USA for more than... Well, guess what? A U.S. citizen child will not be penalized in any way. They won't lose their status. U.S. citizens can stay outside of the country for as long as they want. That is the benefit of going from a green card holder to a U.S. citizen, is that you don't have to ask permission to leave. You won't have any restrictions. You can leave as long as the country you're going to allows you to stay there. You can go, and nobody's gonna stop you here. A person come on a work visa, how can they apply for a green card? Usually the employer has to apply for them to get the permanent residence. If you have an immigration interview and did not turn up, there is any way you can pick up at the case. It is possible sometimes there is a motion, you can motion to reopen. Maybe if there were some circumstances that prevented you from attending, but there was a misunderstanding, that's a possibility. But you definitely have to schedule a consultation to determine what your options could be. Ruth Mobia, you are welcome, and I'm glad that was helpful. Mamana, you are welcome. So keep those questions coming, because I'm here to answer your U.S. immigration related questions. So put your questions in the comments right now while I'm here. I'm going to be here for 5 minutes. Then I'm going to go over to Instagram to finish up a live show there. You're welcome, 49 Drake. But what I want you to know is that the conversation doesn't have to end here. So if you ask a question, I didn't get to it, you can join me over at 9:30 to continue to answer questions and continue the conversation. So the IG is The Immigration Attorney, same as here. The easiest way to do this is go to the link in my bio, and it's going to take you to the Instagram button. Is going to be there. Just click the Instagram button. It'll take you to my page where you can follow and then join me on the live. So you can join me there, but I'm still here. So go ahead and keep putting your questions in the comments. I'm going to finish up the topic in the meantime while your questions come in, and that topic is who can adjust status in the United States, especially when you're already out of status. So I talked about those who can continue to maintain status. So if you're here already on a work visa and it's going to last a couple of years, that's okay. You could possibly adjust status there. Now, if you are out of status, you're the immediate relative of a U.S. citizen. Now, the immediate relatives of U.S. citizens are a limited group of people. It's going to be the spouse of a U.S. citizen, the parent of a U.S. citizen who is 21 and up. That's very important to know. And also if you're the son or daughter of a U.S. citizen who is under 21 and unmarried. So I just listed them out. I hope you got that. Now, if you don't fall into that category, and keep in mind, to qualify as an immediate relative of a U.S. citizen for adjustment of status, you also have to show that you came into the country with some sort of permission. Were you paroled? Were you, inspected at the border? Did you come in with a visa? There has to be some sort of, as I say, legal entry. However, so that also means that even if you're the immediate relative of a U.S. citizen, but you cross the border without permission, like snuck across the border, and you were not inspected, then that is not considered an entry and you would not qualify for adjustment of status. But that doesn't disqualify you from getting the green card. It just disqualifies you from applying, staying in the U.S. and applying. There is a way to still go about getting permanent residence even if you don't qualify. So what is the I-130A for? So it usually provides the full background information of the immigrant, and that just helps them to review the background and basically make sure that that individual does qualify for the benefit they're applying for. And it's for the spouse of a U.S. citizen or permanent resident. I'm going to call one day. Beck, I'm looking forward to hearing from you. In the meantime, I'll always be here at 9 p.m. to answer your questions, so you can always tune in. Now, here are some more exceptions, right? So not just immediate relatives of U.S. citizens who came in with inspection can apply for adjustment of status. If you're in a situation where you're being mistreated by not only a U.S. citizen spouse or parent, but by a U.S. citizen's son or daughter who's 21 and up, or a green card holder spouse, or parent if you're under 25, who is mistreating you. Mistreatment means they're verbally mistreating you or abusing you. They're mentally, emotionally, financially. They are subjecting you to extreme cruelty. Then this is one way to qualify and apply for your own permanent residence. And here's the other part of this. You would not necessarily, in some cases, even if you came into the country, snuck into the country, you can still apply for this as long as you can show that you coming into the country without permission is linked to the abuse or the mistreatment. Also, if you are out of status, you can qualify. Now, here are the benefits of this. It's a way to fix your status where your relative is not helping. It is a way to fix your status when you're out of status. You can get a work permit while you wait for the process to be completed. You don't have to involve your abusive relative, right? The abusive qualifying relative will not be notified because it is a confidential process. So this is also a way that you can adjust status here and not have to leave the country. And you can even get a work permit to help you to settle here while the process is pending. Okay, time is up, but I'm going to head over to Instagram. So I filed for my husband and daughter at the same time. Can one get through before the other? If you're a U.S. citizen, you file for them separately. Absolutely, that can happen. But it really depends on what the circumstances in your case. I don't know what order you did. Where is your husband? Where is your daughter? But yes, one can definitely go before the other, for sure. They don't necessarily have to process them together just because they are either stepfather's child or father-child. So join me on Instagram right now. I'm heading over there. So you can join me and continue this conversation. I'm just moving to a new platform because I already have a scheduled live at 9:30 there. So come on over. To find me, you can go to the link in my bio and you'll see the Instagram button. Just go there. Now, if you know that you want to schedule a consultation, you need personal legal advice, because everything here I gave you is not personal legal advice. It is general information. If you want legal advice, which I definitely recommend, call the numbers all over my videos, or you can go to the link in my bio. Call that number. A scheduling coordinator is available up until 11 p.m. tonight, and then noon to 5 tomorrow and Sunday. So even on your off time, if you have tomorrow off, you can still call, schedule a consult. I'll see you in a few minutes over, at least a few seconds over on Instagram. Thanks, guys. I'll see you tomorrow at 9 if I don't see you on Instagram. Bye.